This is a time set on a final hearing relating to first-day motions in the matter of iCap Enterprises, Inc., case number 23-01243. On the line on behalf of the debtors, we have Julian Grewley.
Good morning, Your Honor.
Taylor Tarasi.
Good morning, Your Honor.
And Dakota Pierce.
Good morning, Your Honor.
Jay Kornfeld on behalf of the Creditors Committee.
Good morning, Your Honor.
Vadim Rubenstein on behalf of Serene Investment Management. As well as Michael Steinberg, also on behalf of Serene Investment.
Good morning, Your Honor.
Assistant U.S. Trustee Gary Dyer.
Good morning, Your Honor.
Darren Cratley on behalf of Redmond Funding Group, LLC.
Good morning, Your Honor.
Matthew Lesnick on behalf of Chris Christensen.
Good morning, Your Honor.
And Lance Miller with Paladin Management Group.
Good morning, Your Honor.
Is there anyone else on this line that I did not identify?
Good morning, Your Honor. This is Vadim Rubenstein. I was on mute when we were introduced. I also have Jay Kraft of Battery Alexander, Serene's consultant, on the line with us.
Thank you. This hearing is being recorded. Please proceed.
Good morning, everyone. I hope you're all doing well and had a nice weekend and remembered to set your clocks back to the extent they didn't reset themselves. So we're here today for the final hearing on 3 of the debtors' first-day motions that were granted on an interim basis, and we're set for final hearing today. I've reviewed the 2 objections, one filed by Redmond and one filed by Wilmington Savings Fund by Mr. Baker, as well as the generalized response filed by the Unsecured Creditors Committee, the status conference report filed by the debtors on Friday afternoon, as well as the proposed forms of final order. I think it makes sense to just click through these in order. Why don't we take the tax motion first? I didn't see anything in the Creditors Committee's response relating to this motion or any other objection or anything indicating that anyone had a problem with it. Why don't I ask Mr. Tarazi if you have anything you'd like to comment on this morning about the granting of the tax motion on a final basis.
Thank you, Your Honor. Callan Tarazi of Buckhalter, for the record, on behalf of the debtors. And no, nothing to add to all of the filings and the updated status report. So unless Your Honor has any questions, we would just ask that you would approve the taxes motion on a final basis with the proposed form of order filed on Friday.
Okay. Thank you, Mr. Tarazi. Would anyone else on the phone like to be heard regarding the debtors' tax motion and the granting of that relief on a final basis? All right. Hearing no objection, the court has reviewed the original motion, understands the relief that's being sought. The relief is appropriate. The court has reviewed the proposed form of final order, which looks good, no comments or edits. So that motion will be granted, and please feel free to upload that order, and we will get it entered. All right. Next is the debtor's request for final approval of the consulting agreement with Mr. Christensen. Again, the court has reviewed the motion, reviewed the proposed form of final order. I did see the Creditors Committee has, I guess, some discomfort with the motion. I don't think it's directly opposing it, but Mr. Kornfeld, why don't I hear from you?
Thank you, Your Honor. Jay Kornfeld for the proposed counsel for the committee. The statement was the committee's concern. There is not a formal objection to the consulting agreement. I think more an encouragement as we walk through the case and we all understand better some of the facts and some of the history here, just to make sure that we encourage both the CRO, which we've done in conversations, and the court to hold Mr. Christensen the letter of that agreement. It's something the committee has consulted with the CRO about and is deferring to his view that this is the right thing to do. So no formal objection, just with that statement, if you will.
Okay. Thank you, Mr. Cornfeld. Mr. Clark?
Thank you, Mr. Debtors. Mr. Gurley will be taking this one.
Okay. Good morning, Mr. Gurley. Please go ahead.
Good morning, Your Honor. For the record, Julian Gurley, Buckhalter, counsel for the debtors. Your Honor, I note Mr. Cornfeld's comment. We obviously, for the debtors, have been consulting with the committee since its appointment and retention of advisors about a lot of these issues. And I'll talk about the gift in a bit, but including the consulting agreement, the debtors' intention is to hold Mr. Christensen to the terms of that agreement. I think that goes without saying. In Mr. Miller's view, as established by his declaration in support of the underlying motion, his determination is that the consulting agreement is necessary within the best interest of the estate to maximize the value of these estates, primarily the real property assets. So the debtors would request that Your Honor approve it. Your Honor, I don't know if you had a chance, I'm sure you did, to see some language that we drafted addressing the interest in Airlink Holdings, which I think strikes a good balance. Just to refresh for Your Honor, Airlink is a non-debtor subsidiary. It has some licenses that may or may not have value. Under the consulting agreement, Mr. Miller is tasked with determining whether those interests in Airlink have value. If they have de minimis or no value, there's a mechanism to, in the final order, to have Mr. Miller submit a declaration to that effect and a notice and a subsequent order authorizing that transfer. If Mr. Miller determines alternatively that there is value in the interest in Airlink, then only after an additional motion and court order would the debtors be able to dispose of those interests in Airlink. So that was only tweak, Your Honor, to the order. I understand that the committee does not have an objection to that. We obviously also drafted that language with Mr. Lesnick from Mr. Christensen.
Thank you, Mr. Gurley, and I did see that paragraph, and I think the process makes sense and certainly seems appropriate. Mr. Lesnick, anything you'd like to comment on or address relating to this motion?
Thank you, Your Honor. Matthew Lesnick for Chris Christensen. Just very briefly, Your Honor, I don't want to go too deeply into it other than to note that the proposed counsel for the committee was involved in pre-petition in the negotiation of the consulting agreement, and that consulting agreement was part and parcel of a pre-petition stipulation with what was called the ad hoc note holders group. And so it was negotiated, it was agreed to pre-petition, and we think it's appropriate.
Very good. Thank you, Mr. Lesnick. Would anyone else on the phone like to be heard relating to the Christensen consulting agreement motion and approval of that motion on a final basis? Okay, well, the court will go ahead and grant the motion. As I said at the prior hearing, certainly it's good, and I understand the creditors committee's view that maybe as a moral matter and maybe as a legal matter, it would be good if Mr. Christensen were to fully cooperate and provide information on a voluntary basis, but sometimes make distinctions between doing things the easy way and the hard way, and doing things the hard way sometimes can be difficult, particularly if a former principal of a debtor doesn't want to cooperate. When I was in practice, my prior law firm represented the Chapter 11 trustee of a company called Girls Gone Wild that was owned by a man named Joe Francis, and Mr. Francis was extremely difficult, and it created massive administrative drain on the estate having to fight with Mr. Francis to get information about Girls Gone Wild. So the law kind of, and the powers of the court and the law kind of run out at some point, and both in practice and on the bench I've seen cases where significant value has been lost as a result of the prior principal not cooperating. Conversely, we've had cases like the Easter Day cases where the Easter Day family, despite not being paid, chose and were very cooperative and open and did a lot of work. There was a declaration I received in that case in connection with the confirmation hearing about folks driving from Washington to, I think, Nebraska overnight without getting paid to do it, just to advance the good of the estate. And that certainly is laudable, and I said so in connection with that case, but it's not obligatory, and it's nothing that the court can compel. So I think in this case, the consulting agreement strikes an appropriate balance in terms of aligning Mr. Christensen's interests with those of the estate and ensuring that he'll be cooperating and not be antagonistic. And obviously, if things change in that respect, I have no doubt that the CRO will terminate the consulting agreement. But based upon the record before the court, and certainly in the absence of any formal active objection to this motion, the relief sought is appropriate, and the court will grant the motion and approve the request for relief on a final basis. I reviewed the proposed form of final order. Looks good. No comments, so please feel free to upload that one, and you will also get it signed. All right. So the final matter before the court is the debtor's requested relief for final approval of the DIP financing provided by Green. I did review the two objections. Didn't hear Mr. Baker on the phone today, and the status report indicated that Wilmington's concerns have been resolved based upon the changes made to the final order and really the staging of any priming relief for further hearing. The status report did indicate Redmond Funding Group is still objecting, and I will hear from counsel momentarily. But I guess before I do that, Mr. Ruin.
Yes, thank you, Your Honor. I'll be brief. For the record, Julian Gurley, Buckhalter for the debtors. Your Honor, we did get, as you noted, two formal objections. We also, I would say, just for background, Your Honor, obviously we're in discussions with the creditors committee and the DIP lender over the final form of order. There are some comments, I think, more clarifications and the like that we were happy to accommodate, and we appreciate Mr. Rubenstein and Serene also accommodating these from the committee. I would say the principal comment from the committee, I don't think we had anything that would rise to a level of even an informal objection, but were discussions with the committee and reflected in the committee's response to the first day motion. I'm sure Your Honor saw around the pricing, candidly, of the DIP financing. Your Honor, we're aware of it. It is obviously very expensive. DIP financing, as we described at the first day hearing and in connection with Mr. Miller's declaration in support of the DIP financing, it is the only game in town, and it's absolutely necessary to make sure that the estates are able to have the liquidity necessary to pay administrative claims so that we can, as quickly and as efficiently as possible, get these cases to our planned resolution. And the change, as Mr. Kornfeld noted in his response, that addressed their point largely is in Section 610 of the final DIP order, which now provides a 14-day prior notice period before the debtors tap the final DIP amount. So I'm sure Your Honor will hear more from Mr. Kornfeld at the appropriate moment on that. With respect to the formal objections, Your Honor, my understanding is, I think Mr. Baker is on the line, but we do have confirmation that revisions to the final DIP order that were suggested by Wilmington and fully accepted by the debtors in the order address their objections. So I think those are resolved. In terms of substance, Your Honor, we did reach out to counsel for Redmond Funding after we saw the objection, just for the sake of absolute clarity on the record. The debtors are not at this hearing or under this final order seeking to prime Redmond Funding or any other creditor. We think that the revisions suggested by Wilmington apply, and to the extent necessary, make that same clarification with respect to Redmond. I don't, Your Honor, candidly really know what they intend to prosecute in terms of an objection today. So perhaps the most efficient way to proceed is for me to just reserve the ability to respond to Mr. Crowley. Thank you.
Thank you, Mr. Gruley. Ms. Kornfeld.
Thank you, Your Honor. As Mr. Gruley stated, and appreciated by the committee, we did have extensive conversations with counsel for the debtors and the CRO, as well as Mr. Rubenstein, and appreciate those conversations and discussions. At this time, the committee has gotten comfortable with the language in 610 and doesn't have any continuing objection. I think as we did with Mr. Christensen's consulting agreement, in part the response that we filed was to treat this as a bit of a status conference and continuing education for the court and the consciousness of the case. The positive is that in our conversations since we've been engaged by the committee, which has only been 9 or 10 days, have been very positive with the CRO and his counsel. I think that the view is consistent with what we have set forth in our response, that it's the type of case where the CRO on behalf of the debtors and his counsel and the committee and its counsel and professionals really ought to be working as much as a unitary body as possible to maximize recovery here. Those conversations that we've had with Mr. Miller and his counsel have been consistent with that approach. We've made considerable progress on a couple of issues already and are working through how to basically handle the workload in this case. At some length, our response really wanted to focus the court and get the understanding out there for everyone that the assets relative to the complexity of the issues before this court and the magnitude of liabilities, the asset values are relatively small and limited. And we all want to be aware, and I think there's consistent agreement between the CRO and the committee that we need to work efficiently to utilize those funds and to maximize the efforts to recover. Hence the request for the committee that be advised of a decision by Mr. Miller that he feels a need to borrow further under the DIP and the notice period. And we appreciate that. I think we'll all work in that vein. Wanted to report that to the court and to say that at this point the committee is comfortable with the order and has no further objection. Happy to answer any questions Your Honor may have.
Thank you, Ms. Kornfeld. I understand the concerns the committee has about pricing, including kind of the amplified concerns in the response, but I guess is it fair to say that at this point the committee agrees with Mr. Gruley's statement that this really is the only game in town and it's very expensive money, but it's better than no money in conversion to Chapter 7 at this point?
We agree that the funding is necessary, Your Honor, and that the pricing is expensive. We understand that the process was run, an extensive process, and we understand that this was the only available DIP. If there's a possible substitute down the road, we can all come back to the court with that in mind. We've had those discussions. But for now, as I say, we have no objection to this order before the court.
Okay. Thank you, Mr. Kornfeld. I understand.
Thank you.
Mr. Baker or other counsel for Wilmington Savings Fund on the phone today? Okay. Yeah, I don't think I heard Mr. Baker call in. Well, I will accept the debtor's representation that the language in the proposed form of final order resolves the Wilmington objection, and in any event, the objection will be overruled for failure to prosecute in any event, which, just to be clear, is not overruling on the merits of any subsequent priming request, but will be overruled based upon the addition of that language to the proposed final order. Mr. Crowley.
Thank you, Your Honor. And To be candid, probably we feel a lot better after the Unsecured Creditors Committee had spoken with the debtor, because silence to our client has been an issue. As we highlighted with the declaration, there's previous communications after the bankruptcy was filed without notifying us of the bankruptcy filing or the first day motions. We reached out to debtors counsel without receiving a response until we filed the formal objection. When I spoke with debtors counsel after filing the objection, we asked for details about the spending in this case. We had not received any follow-up regarding that. And our concern was a little bit of the tail wagging the dog here, is that the budget that they provided for includes lending of about $4.6 million in the first 3 months of this case, that's through December. That's about 88% of the amount of the loan that would be taken prior to them requesting priming. Since we have no schedules, there's been no 341 hearing, the debtor has not been communicative with our client. We worried that there was going to be an argument that, well, you didn't appear and argue about the DIP financing. We had to spend this. You've effectively conceded that. So therefore, the issues regarding whether the earlier spending was appropriate prior to the priming motion are out the window. We understand from debtors counsel that their understanding of the proposed language reserves that. What they added was that the priming would only occur upon a subsequent motion with additional briefing, and then it says, and with all rights of senior lenders reserved. My understanding from them is that that includes objecting to what we don't know right now about the spending and the reasonableness of the initial advances on the DIP financing. If that's the case, and with the Unsecured Creditors Committee's response, my client is a little bit more comfortable with this. We just don't want anything taken from this hearing today being used in advance of supporting the request for priming down the road at that subsequent hearing. Obviously, we're a little panicked when the initial DIP agreement seemed to say that they could get that financing on 5 days' notice. That seems to have been removed here. Now it's on regular notice and hearing period. I don't see anything in there attempting to shorten time. With that change and with that understanding, I think that would resolve our objection, Your Honor.
Okay, very good. Thank you, Mr. Cratley, and I understand your concern is really that the debtors would argue, well, look at all the milk that's already out of the carton, and you were there before the milk got poured, so therefore you're kind of stuck commenting about that. You'd like to avoid that.
That's exactly correct, Your Honor. Since we have no disclosure of what this $4.6 million is being taken up from, we don't want that being used as the justification for the later priming.
Okay, I understand. Mr. Grewley.
Thank you, Your Honor. For the record, Elaine Grewley. Your Honor, I think what I'm hearing from Mr. Cratley is, given the revisions to the DIP order, apparently the committee, the statement that the committee is comfortable with the entry of the final DIP order satisfies resident funding, that at this point the order can be entered, I guess, without any further objections from them. But I do absolutely, to the extent necessary, I'm happy to clarify on the record that we would expect there to be, as the final order now requires, a subsequent motion, and we would have to prove up our case in chief as the debtors under Section 364 of the Bankruptcy Code if we did want to unlock that additional $1.5 million of priming availability. Your Honor, so I think with that, I'd request that the court enter the order respectfully. Thank you.
Thank you, Mr. Grewley. Just to kind of put a finer point on it, in the event that we had that subsequent hearing and the debtors would be making their case for priming, Redmond could make the argument if they wanted described on the record today, right, without an argument that they're stopped from doing that in terms of the need for the incremental priming component. Would that be fair? So we're not.
Yes, Your Honor. You're absolutely. It strikes me as that they would be up against the business judgment rule, but that's fine. Yes.
Okay, but they wouldn't be. You wouldn't be arguing they're a stop or right. I might say it's wrong. I might say I disagree. That's not a good argument. You lose on the substance, but there wouldn't be a procedural kind of gotcha at that subsequent.
I agree, Your Honor. Yes, thank you.
Okay. Would anyone else on the phone like to be heard regarding approval of the DIP financing on a final basis?
Yes, Your Honor. This is Vadim Rubenstein of Loeb. I just wanted to thank committee counsel and debtors counsel for working cooperatively with us. It's a two-way street in terms of our participation, and they've really made our lives a lot easier, and I think saved a lot of money. So I just wanted to commend both parties.
Very good. Thank you, Mr. Rubenstein, and that's definitely good in every case, and I think particularly good in this case, given the issues that the creditors committee raised in its response and that Mr. Kornfeld raised today. The court is, based upon the statements on the record today and the changes made to the final order, including the reservation of all parties' rights with regard to subsequent timing, will press the court is prepared to grant this motion on a final basis. I have a handful of with minor nits I can give you. I'm working off the red line that was filed at docket number 124, and the pagination just on the bottom of the red line. So hopefully you're able to follow this. On page 4, paragraph Romanet VI, about midway through that paragraph, there's a line that starts inherent subsequent to this final, and then orders missing the D. Fix that. At the very top of the page, I think it should be debtors plural rather than debtor singular apostrophe S.
Yes, Your Honor.
Page 13 of the red line, paragraph 1.1. You can just put the bracketed each docket reference number after the motion there. I know it's early on, but when we're training the AI, it'll be helpful to just make sure it fully fits and ties back to the docket number. Page 14 of the red line, line 2 at the top of the page, subsequent to this final order expressly, and then granted is missing the N, so it's rating. Page 15 of the red line, line 7, there's another rating, so just and there. Finally, on the page 31 of the red line at the end, it looks like a period might have gotten stopped at the end of paragraph 6.9 at the end. I'm not.
Yeah.
Okay. Otherwise, the changes all look good, look appropriate. No further issues. With those changes, interchanges, the court will grant the motion and the order. So I guess that covers the motion that we're hearing today. I wanted to ask, we have an omnibus hearing date scheduled next Tuesday, November 14th. I don't think anything's been set. I have a good sense of the staff report that the debtors filed on Friday and the response and then the statements on the record today. So would you like to keep that 14th date on calendar, or you can strike that consistent with Mr. Kornfeld's comments? I'm happy to minimize the need for folks to get on the phone if we don't have any work to get done on the particular day.
Yes, thank you, Your Honor. Yeah, we were looking internally at that date this morning, and from the debtor's perspective, we don't believe we need it. We're not planning on setting anything for an emergency hearing or anything like that, and nothing, as you noted, is currently on the calendar for us. So from our point of view, we absolutely could cancel that canvas conference and omnibus date at this point.
Okay. We will just do a minute entry striking the November 14th date from the calendar. And then our next currently scheduled hearing will be on Tuesday, November 28th, so after Thanksgiving. All right, anything further to cover today, Ms. Lewis?
No, thank you, Your Honor, for your time. We really appreciate it. Thank you.
All right, thank you. Mr. Kornfeld?
Nothing here, Your Honor. Thank you.
Anyone else on the phone today? All right, well, thank you all for your time and your efforts. You made this a very easy first day hearing and second day hearing. We will keep an eye out for those orders and get them entered, and we will plan to speak with everyone again on November 28th. Thank you, everyone. Have a great rest of the week. We're adjourned.
Thank you.